Commissioner, thank you very much. That was so informative. I think everybody here enjoyed it. So thank you very much for coming here.
Thank you. And thank you to all of you for your interest in this and your hard work to continue to make sure that persons realize the importance of this. I really appreciate it.
Okay. All right. Thank you. At this time, let's go ahead and have Special Judge Kirstin Pace. We are honored to have such good speakers here. Carrie started off, we're going right here. So we're just excited to have you all here. Thank you very much.
Well, good morning, everyone, and thank you to the committee and certainly to Representative Randleman for including me in our discussion today. I am Kirstin Pace. I'm a special judge in Tulsa County. I'm in my 16th year doing that type of work. Prior to doing that type of work, I was an insurance defense lawyer, mostly representing actually doctors and hospitals. So I've always been somewhat interested and comfortable with working with those kind of clients in my private practice. And in segueing into my judge job, I was very fortunate. My very first job was doing the civil mental health docket in Tulsa County. In the 16 years that I have been very fortunate to serve the 14th Judicial District, I've about 10 years overall, off and on, I've been doing that docket every day. It is a 5-day-a-week docket in Tulsa, America. And I've been doing it every day for the last 8 years consistently. Oh, I'm terribly sorry. Forgive me. Is that better? Yeah, I can be soft-spoken. Forgive me. Not always. Well, again, as a current seated judge, it's important for me to explain that, of course, I'm invited to offer education always on the law and on our legal processes as they serve Oklahomans, but I am careful to refrain from political commentary or any kind of commentary that would be construed to drive funding. That's not within my purview. But today I think it's very important to come and talk about what I observe every day and some of the tools we have in Tulsa County that, frankly, we've used since before I was a judge. I think to really understand some of the diversion opportunities that we're wanting to focus on today, I think it's very important that I explain first some of the options in a civil mental health court and that I explain the differences between civil mental health court and other specialty courts or criminal mental health courts. Again, I also handle many other dockets. In Tulsa County, we average about 1,000 civil commitment mental health cases a year, and each case is not just one presentation typically before a judge. A person with one mental health civil case may appear before a judge many different times. So it's a docket of that volume, and again, it requires a 5-day-a-week commitment on our part and on many of our support staff's part. I did include just about a 6-slide handout. I don't need it to be broadcast, but hopefully it'll be disseminated today. If anyone needs my contact information, would like to email me for more details about your respective jurisdictions, please feel free to do so. I would be glad to reach out to different local courts and counties. I was doing that last week with an adjoining county to Tulsa to try to explain to them how we've been doing diversion in Tulsa, frankly, without additional resources really for many, many years. Again, with the daily civil mental health docket, we're primarily focusing on patients or respondents who are ill enough with their psychiatric symptoms that they require inpatient civil involuntary commitment for treatment. Of course, that's not everybody, and my lens is small sometimes because typically I'm looking at the most ill folks who have really the greatest risk of harm to them, and sometimes from the community's perspective may present a greater risk of harm to the community only due to symptoms that have become out of control for whatever reasons. Some respondents that I work with, of course, have current criminal charges. Some have potential civil charges, and of course many have no charges at all. All right. So in criminal mental health court, or our Anna McBride Court, which is a program that I was fortunate to help with the initiation of in Tulsa some years ago, I would guess That was probably 13 years ago. Everyone in criminal mental health court has to have a current pending criminal charge. That court has the power under existing law to treat that participant in criminal mental health court with potential jail sanctions or a sentence if that's appropriate. But everyone who participates in criminal mental health court, I'm not currently the judge who calls that docket, but everyone who participates must be competent to plead into that program and to succeed, we hope, in that program to avoid sentencing and incarceration. Most of the folks that I work with at the time that I encounter them in civil mental health court are frankly too ill and perhaps are not competent to plead or to participate into an excellent program like criminal mental health court, all right? Let me make sure I explain some of the other specialty court programs that would be available in Tulsa County. Again, we're very grateful to have a pretty robust alternative courts program system.
She actually emailed those out to everyone.
Okay.
So you have them in your email if you want to look, or we can have her copy them off.
Yeah, and the slides that are sent are not designed to be particularly helpful. Unfortunately, I don't have the kinds of statistics that the commissioner was gracious to share with us, so you're not missing much. You can look at it later if you'd like to rehearse some of the terms, remind yourself of the terms, or how to contact me. Okay, again, we have mental health court, criminal mental health court. We have drug and DUI courts, veterans court programming, and we do have that new misdemeanor program that you heard the commissioner speaking about for lower level, perhaps misdemeanors. We offer an opportunity now on Mondays for folks charged with such matters to come very informally on Monday and meet with yet another different judge in Tulsa County. We're grateful he's doing that. And we're just growing that program to see how many people would present to dispose potentially of their misdemeanor with an outright dismissal of their charge if they will come on a Monday, visit with the court staff and the judge there, the district attorney, the public defenders that are available there, agree to treatment, substance and or mental health, other mental health treatment. And once those folks have engaged in treatment, the judge, the district attorney, have the opportunity to completely dismiss a misdemeanor charge. So we're excited about what we'll see develop with that particular program. I don't happen to be the judge on that program either. So for our civil mental health court, which is my docket, I want to make sure folks understand there are 4 basic categories of respondents that we deal with in that particular court. Every morning I'm presented with quite a bit of paperwork, I'll tell you. I hope they're doing it right now in my absence. But in custody respondents, we call them. I'm not a fan of the term custody, but it's a practical term. Those are folks who have already, for one reason or another, presented to a local area hospital. I work with up to 14 different facilities that use the Tulsa County Court for filing their mental health petitions. Primarily, that's the Crisis Care Center, often for our Medicaid patients, or the Tulsa Center for Behavioral Health for uninsured patients. So folks who present to those facilities for whatever reason that are determined to need to stay but do not wish to stay past the 5-day period of detention. Those folks have a petition filed with me every morning, 5 days a week, quite a few of them. Then we have what we call out-of-custody respondents, which is somewhat, I understand, unique to Tulsa, although the law does certainly provide for it. For out-of-custody respondents, that means you may have a citizen in your community who will not present voluntarily for any kind of mental health evaluation. Typically, they are more chronically ill and having an acute episode. Those folks may actually be, under our existing law, petitioned for a potential evaluation and up to 3-day detention for a qualified mental health team to make an evaluation about whether that person needs hospitalization or not. All of this is per 43A OS Section 5-410, and this is to respond to our folks in the community who may pose that substantial likelihood that they're an immediate risk of harm to self or others. And that's a way to get that addressed by a family member. There are many different folks who can file an out-of-custody petition, not just a list of qualified family members, but also district attorneys, licensed mental health professionals, under some circumstances, correctional facility officers may do it, and peace officers just generally may file out-of-custody petitions. We've been fortunate in Tulsa longer than I've been a judge to have a very robust system where out-of-custody petitions are received directly from family members every day. And as a judge, we make the best decision we can and do a little bit of research on whether that person should be detained for evaluation. We're very fortunate that we have local facilities to do those evaluations, although we, in my view, could benefit greatly from more. And we also have a Tulsa County Sheriff's Office that is committed to staffing that docket. We have a mental health unit currently for well-trained, in my view, officers and deputies. One of them's been doing this primarily for over 15 years. We have others who are very experienced, and this is what they do every day. It's, I think, a great example of community policing, helping families get their loved ones who will not present for treatment to a hospital before they have had a potentially dangerous law enforcement contact or been vulnerable and dangerous alone in the community. So after a period of involuntary treatment, again, the existing law would allow a court to court order a patient to outpatient treatment for either in custody or out of custody respondents. Under 43 AOS, that'd be 5-415 and 416. A judge in my position who has made often a challenging decision that someone requires treatment after hearing, upon evaluation suggesting treatment, and a person who objects to it, we enter an order of commitment. That happens every day in my community. But the care providers are charged with the responsibility to always be monitoring what's a less restrictive alternative to that inpatient treatment. And when and if they determine that a less restrictive option like court-ordered outpatient treatment is appropriate, they petition the court for court-ordered outpatient treatment. Again, this would be a person I've already seen once for their commitment hearing. I've already made a decision, perhaps over their objection, that they may require inpatient treatment, and their doctor and whole care team have decided that after some period of treatment, may perhaps reestablished on their medications, this person can now leave the hospital. But we view it under existing law as a conditional release from the hospital. Essentially, you're released from the hospital if you follow the suggested treatment plan. We review those plans very carefully. We expect each treatment plan to be quite clear about what are the proper discharge medications for this individual. What is their agency that they are to work with on their outpatient treatment? And they are, as Commissioner Slatton Hodges explained, they're given what is becoming sort of an industry term of art, that soft handoff, that appointment with a real person, with a real name, with a real location and phone number. We consider whether it's telehealth or whether it can be in person where that's appropriate. And we make sure these folks on court-ordered outpatient treatment also have a reasonable discharge plan for housing when possible, not always possible, and that they have meaningful family support, release of information if that's necessary to include family in discharges. And also we're looking at transportation pieces and income pieces, trying to help make sure folks who have now been restored to a point where they can make some of their own treatment decisions might be in a position to look for Medicaid as an option or to apply for disability perhaps where appropriate. Again, in a show cause setting is when someone who's been court-ordered to outpatient treatment after inpatient treatment has demonstrated an unwillingness to follow the court's recommendations for treatment, which are really the provider's recommendations, and or those recommendations upon discharge from the hospital have proved to be insufficient to meet the level of need for that consumer. And so again, under existing law, those are already options. But the providers in the hospitals, frankly, the MDs and DOs in the hospitals, drive that decision. As a judge, I am not in a position to impose a court order for outpatient treatment upon anyone unless the provider who's assessed and evaluated them recommends it to me. And under 43A, of course, we're trying to do the least restrictive thing for patients involved. It's a very stressful experience for any patient to be involuntarily committed. Typically, court-ordered outpatient is not recommended right away after a first admission. Usually we're seeing court-ordered outpatient after involuntary commitment, only after someone's presented with several involuntary inpatient episodes. Also, we will use court-ordered outpatient treatment sometimes to encourage providers to see that we have a social issue with a person who's reoffending, often coming into too much contact with the criminal justice system. When we divert those folks from jail to a hospital for assessment, we are fortunate to have providers in Tulsa that see that social need as a reason to court order folks to outpatient treatment after a period of inpatient treatment. I should segue to our assisted outpatient treatment law. Assisted outpatient treatment is another very important tool, and it's distinct, in my view, under the existing statutes from what I've just talked about for court-ordered outpatient in Tulsa. AOT, as we call it, the very important Mark Costello Act, it helps folks who have not reached the level of needing inpatient treatment yet, and our goal is to prevent that by having a judge find that person after recommendation from a licensed mental health professional that this person needs assisted outpatient treatment to prevent that hospitalization or that law enforcement contact. Frankly, in Tulsa, because we had already been doing court-ordered outpatient treatment for some time before our AOT law was passed, we've had fewer AOT clients. We find ourselves serving more people who have already ended up in the hospital, as opposed to having the privilege to prevent hospitalization with the AOT program. But that's how I've always thought of it, the difference between preventing an admission before it happens with AOT versus dealing with an admission at discharge after an involuntary admission has been not preventable. All right, so you have to think about those different options when you look at how in Tulsa we endeavor to sort through who might need which option. And for our folks who came into the jail, city or county jail, which of those folks may need one of those different options. Every morning we do this in Tulsa, frankly, at 9 o'clock. I'll get all the petitions from hospitals in our area who need to keep patients that don't want to stay. I get all the petitions from family members, loved ones, other folks who want to get their loved one to the hospital so that they can have a determination of what they need. We call those out of custody petitions. And then we get all the show cause requests from mental health providers in our area. There's many excellent providers. We get a large volume from Family and Children's Services and Counseling and Recovery Services of Oklahoma when we have a court-ordered outpatient who is non-compliant or their treatment plan is no longer adequate to meet their level of need. I look at that paperwork every morning to determine, is a show cause hearing necessary? Should these folks come back in for reassessment at a hospital and another hearing from the court to determine if they're in compliance with their treatment plan or if their treatment plan needs to be changed. Again, this staffing that happens every morning, we have really existing staff who's always done this over the years. It is expanding, and I'm pleased to see that. The district attorney meets with me, who's assigned to that docket, the public defender assigned to the docket and assigned to every client who has any kind of court-involved mental health treatment is there. The court clerk, who's very well trained in processing what you can imagine is a lot of paperwork from 14 different hospitals, all of whom social workers do it a little bit different, all of whom need a little bit, understandably, of hand-holding on how do they dialogue with a court to get good treatment for their involuntary patients. So we've got DA, PD, me, court clerk, and now we have some case managers and court liaison who assist to help court language translate better to provider language, which is a real challenge. Sometimes our court process can seem pretty unfriendly to the social worker who's trying to plan a safe discharge very rapidly for their client. Okay, so we discuss patients every morning who are already on court-ordered outpatient treatment, the folks who need to come in with a new petition for whatever reason, and then another feature we've always done is with the help from our sheriff's department and jail staff and jail medical staff. Every morning we have a bond docket in Tulsa. So our bond docket often re-identifies folks who we know have come into contact with us for what we believe are mental health reasons over and over again. The attorneys on the bond docket can flag those individuals, get an informational email or text or whatever it is, or protected health information, of course, to the staff on my docket and say, heads up, we may have someone who may have worked with Judge Pace's program before. Is there a way to assist them? And in that way, we can get the DA's office thinking already early, every morning at 9 o'clock. Is this someone who might have their charge dismissed completely? Because we believe they'll proceed with voluntary treatment. And the screenings that the commissioner referenced are very important in helping make those decisions for district attorneys. In my view, I shouldn't speak for them, but many folks can have their charge suspended for a bit while they're diverted to civil mental health court for assessment, evaluation, possible treatment, and often court-ordered outpatient treatment. We have found the district attorneys may be more comfortable with the dismissal of charges, or at least suspension of charges, while a person is receiving treatment after they demonstrate a period of compliance on court-ordered outpatient treatment. Often, even the victims of some crimes, where there are victims, oftentimes they're not, of course, but victims can be consulted and often will elect to the district attorney, I don't want to see those charges pressed. I now am confident that we're addressing this as a mental health issue on a community level. So that really does happen every day on the docket. We also get an opportunity then to decide, perhaps we have a person whose criminal charge can't be dismissed, but they would be an excellent candidate for a specialty court program, like criminal mental health court, drug or DUI court, veterans court, the misdemeanor diversion program, which we're implementing. It's a good time to filter and sort those issues every morning. We also, of course, will encounter folks who are having competency issues in a jail, and this gives us every morning the chance for the district attorney to wonder if we have someone who is going to be competent to stand trial, if they're going to be competent to plead, and that helps the district attorneys and public defenders be making earlier decisions about whether someone's best route perhaps is to attempt to restore their competency after a competency evaluation at the Oklahoma Forensic Center and up to 2 years of competency restoration treatment. Again, recall, even after competency restoration treatment for folks who have probably a serious criminal charge, who have a serious mental illness, who are unable to be processed fairly and constitutionally under the criminal system, they often are sent to civil mental health court after their 2 years has run for the kind of community supervision I've referenced in our court-ordered outpatient treatment program. So we've been doing that for a long time when folks, frankly, time out of the competency proceedings through the forensic center. Another thing to keep in mind. So accordingly, that's a lot of filtering and sorting to happen every day. And frankly, it happens best with staff who are pretty familiar with these individuals. In a large metro area like ours, it takes a pretty large staff to make sure we're familiar with these folks. And sometimes we feel that we have a little bit of experience on what's worked for them in the past and what has not when we need to try something new. In a smaller area, I think it can work just as well, perhaps if not better. Because I think those numbers may be a little smaller and more manageable, although, of course, the options may be smaller, too. And that's something we'd like to see expanded for rural counties to have access to what we are fortunate to try to do in Tulsa. So with these basic options in Tulsa, we've been diverting folks regularly from jail for some time. As a judge, I'm not a statistician, and I don't really have the luxury of someone to keep statistics for me. I would approximate estimate that we have historically diverted 10 or more people every month just straight from jail. I think that number is really increasing. People also are diverted to municipal jail programs as well, I should say. We do have a municipal judge program that helps people who just have a city-type charge. Usually I have state-type charges in my court. Since obtaining a new grant in late 2020, I believe, our local district attorney's office also has now more resources and mechanisms to help filter, sort, and identify these defendants and try to make better decisions on which program they would fit into the best, and make better informed decisions on whether outright dismissal of charges is correct, whether suspension of charges is advisable, or whether charges really must remain in place, but we have a specialty court program, our forensic system, to deal with it. Since the district attorney grant, of course, I'm not involved directly in any of the grant issues, but I'm trying to assist with keeping some new statistics so folks can be encouraged that perhaps this effort, and it is a big effort, is worth it and will pay off in terms of folks who are kept completely out of the criminal justice system, or with folks with criminal justice contact, they have a lower rate of recidivism. In just the 8 or 9 months we've had this new grant up and running, we believe we see a drastic change in recidivism. That's the change we always felt was occurring, but we didn't have the statistics to really prove it before the grant. So in any event, and so 5 more minutes for me, or is it time for questions? Yeah, okay, well, we'll try to wrap it up. So again, when determinations are made by a DA's office or perhaps jail medical that a defendant is better served to leave jail for evaluation or treatment in the community, that kind of decision gets communicated to the treatment team at the evaluating facility. And we have prescribers, DOs and MDs and residents in Tulsa who come to understand that jail-diverted clients from the Tulsa area very likely have a set of social situation that makes it important to court order them to outpatient treatment. So there's often an informal approach that folks who are coming straight from the jail, usually on a PR bond or something of that nature, to be evaluated by doctors at the hospital. If the doctors feel that they are in need of treatment, they may typically receive at least a short period of court-ordered outpatient treatment. We have a hearing where I go over the treatment plan with that individual and remind them of the basics. I shouldn't generalize too much, but the basics of the plan, we do try to keep them individual. The basics are, as you might imagine, take your medication as prescribed. Don't change your medication unless the provider working with you suggests you change your medication. The second rule is often meet with your provider, however often they want you to, whether it's on the phone or in person. We try very hard to also then, once in that program, be always looking for a better program within the agency to address things. Often folks will discharge homeless. They may work with the homeless outreach team with Family and Children's. With some help from that team, we may get disability income on board for that person. We may secure stable housing. And over time, we may see folks eligible for PACT team, programs of assertive community treatment you hear so much about, that we're very fortunate to have 4 teams now and growing to 5 and beyond very soon. As you may understand, PACT team providers work with anyone in Tulsa, but a lot of court-ordered outpatients by going to them to offer their services. Folks who are perhaps on monthly long-acting injectables can receive their medication in their own home at the local Quick Trip, if that's closest to the place they stay outside in Tulsa. Anywhere. And so we're always looking for refining our court-ordered outpatient treatment to improve it as the patient improves, because, of course, under 43A, we're looking always for that least restrictive option. I think it's important to understand court-ordered outpatient can be changed at any time. It can be reviewed. It can be extended, shortened, modified. There are very liberal standards for that under the existing Title 43A law. It's just a matter of, I think, providing education and training to different areas of the state on how to use that law effectively. I'll skip again to a little bit more about what my concerns are. Our challenges at this point, in my view, would be we could benefit from more MD or DO or at least prescriber level staff to help, once we secure folks, divert them, get them in for evaluation. They need to be evaluated as quickly as safely possible. That needs to be a 24/7 thing. If it could be, it would help. And we need to meaningfully determine each of those folks' levels of need. I would tell you that lack of bed space, longer-term bed space, is a challenge for the docket I do in Tulsa. In Tulsa, I hope I'm close to right. I believe I am. There are 56 uninsured beds at the Tulsa Center for Behavioral Health. We're grateful the Crisis Care Center has expanded to 20 chairs for 23-hour or less treatment, and I believe 20 beds for folks who need to be there longer than that. But if you add all that together in terms of folks who can stay overnight, we're looking at approximately 76 beds in Tulsa. We're glad to have them, I would say. But in Oklahoma City area, there are far more beds than that, frankly. And we just don't have, with the level of illness, the acuity as I've seen develop in the last 16 or so years I've been doing it, a 5-day stay is insufficient to stabilize, in my view, many people. I'm not a physician. But I do think we need to have longer-term beds. And many folks, even at their baseline, are unable to provide for their basic needs. And to have longer-term facilities with meal support would be very, very helpful. We struggle with that every day. A lack of discharge planners who have time to make the best discharge decisions they can. As the commissioner was explaining, we're getting some new programming, I think, in the Oklahoma City area for that. We'd love to have more in Tulsa, again, to help that discharge planner, who's under quite a bit of pressure most days, to discharge as many patients as quickly and safely as they can. And they've got to get that person into housing, get them a meaningful appointment, get their medication straightened out. It's a daunting job, and we need more young people, frankly, that would be willing to go into that type of work. We have a lack of co-occurring beds, of course, in Tulsa. We used to have a co-occurring unit at the Tulsa Center for Behavioral Health. Don't forget, folks who are in need of treatment under Title 43A in Oklahoma are not just folks with mental illness issues. The statute still reads that folks who are alcohol or drug dependent to a point where they are an immediate risk of harm to self or others, they are entitled to the protection of Title 43A as well. So I may be close to overtime. I'd love to entertain questions as I can. I hope that was helpful.
Yes, at this time, if you do have a question, refer it to the chair, Manger, with one follow-up. So we'll try to disperse the questions around. Thank you.
Representative Williams, you're recognized. Thank you for your service and what you do to help people. Sometimes it's not a very rewarding position. You don't get the accolades maybe that you deserve, but I appreciate what you do. Given your resources in Tulsa County, and you sound like you have quite a unique setup there, I don't think they have that in Seminole County. So, but how effective do you think you are on a percentage basis with the clients that come to you with the resources you possess?
I would say, and I think about it on a case-by-case basis, that's my job, is to look at each individual case as important as the last. I have folks who only see us one time, and they're very persuaded by court-ordered outpatient treatment. When they regain control to make their own medical decisions, they appreciate that, and they want to stay in control of their own medication issues and keep the court out of it. It's surprisingly effective, often for first-time breakthrough folks. Many times those are young people, 19 to 25 years old, having their first bipolar manic episode. It is a real privilege to get to work with people and try to educate them that they're not alone in having that kind of diagnosis at a young age, educate that family that they're not alone in learning about such an illness. Of course, we have chronic patients who we see. I have patients with 60, 70 admissions. And those folks, again, a privilege to work with them, because when you see them as regularly as we do, you get a better idea, frankly, of how is our community doing helping this person? What have we failed to do that we could do better? So I can't give you a statistic. If I did, I would be making it up. I would not want to do that. I hope that by next July we'll have statistics. The whole point of it, in my view, is to get people back in before they decompensate to a point where they're going to require a longer length of stay. We do a pretty successful program where folks who need monthly injections may not even really be hesitant to take their monthly injection, but they lack insight to know they need to go get it and planning preparation skills to do that. We have a very successful program where we pick people up, take them in, give them their injection, and in less than 23 hours, they're home, back to family, back to work, or back to doing what they normally do. So it's very effective in many different ways. It's frustrating often because, folks are not inclined to believe they need to take their medication all the time. I apologize if that wasn't more specifically responsive.
Yes, you can have one follow-up.
Yes. Thank you, Mr. Chairman. Have you engaged civic organizations and churches as volunteer support in this process?
In Tulsa, we're very fortunate to have a particularly active chapter of NAMI, the National Alliance for Mental Illness, and I'll tell you that many families are directed to our courts programming by the NAMI organization. That's probably one of the number one places. We get a lot of referrals from COPES. Again, the program for the statewide emergency hotline that the commissioner referenced is already online in Tulsa, in our Tulsa area. So COPES is our 24/7 emergency hotline for mental health. We get a lot of referrals, frankly, from there. We get a lot of referrals from law enforcement directly. When law enforcement is struggling with that decision of whether someone meets emergency order of detention criteria or something else. And law enforcement will tell families struggling with multiple law enforcement contacts to come and see the court about initiating an out-of-custody petition. Without those resources, I don't know how we would be able to help as many people as we do, and it concerns me for rural counties that don't have any of those resources. But I can tell you, we started doing this in Tulsa without resources, but with the commitment of a district attorney, the commitment of a public defender, the commitment of a court clerk who was willing to do the paperwork and help, and very importantly, the commitment of the Tulsa County Sheriff's Department, who staffs, again, this unit with folks who I personally believe are the best trained in Oklahoma to go and find patients and get them back to treatment when they need it but can't choose it for themselves. These are folks, they know these patients' family members. They know where they live. They know what quick trip they go to. They know what kind of music may calm them down if they're in the back of their patrol car. They know those things. And to have that level of community policing, I think, is probably the most important aspect of what I do. And I would not be able to do this docket without that engagement of law enforcement. I wish we had more cooperation interagency. That can be difficult, indeed, between city and county agencies for law enforcement. But they have different resources, challenges, and limitations. In a smaller area, it would be hard indeed. But I'd be glad to explain it to any county that wants to talk about it. You bet.
Representative Harden, you're recognized.
Thank you, Mr. Chairman, and appreciate you coming in. Got a couple of questions. First of all, do you have a problem or an issue accessing inpatient state facilities for acute or residential need?
Yes. And it goes back to the bed issue that I'm talking about. I think there is an idea, and a misunderstanding really I had at first, that if we had a patient that needed more than a typical length of stay at the Tulsa Center for Behavioral Health, that they could go to Griffin or somewhere like that and receive a longer period of inpatient treatment. I have not found that to be true. We do have higher superutilizer clients that sometimes staffings will occur, and providers, the Department of Mental Health, other agencies will try to secure a longer-term bed for that patient. But beds for patients longer than 5 to 10 day stays are very challenging to come by, and more now than they were 20 years ago when I started the docket. When I started the docket, again, 16 years ago, I should say, it was a page or two long every day. And now it's 8 pages and more every day. And acuity, in my view, I'm not a provider, not a doctor, but acuity is much more severe than it was when I started. Sorry, was that responsive?
Okay, if you don't mind, I'm going to have to stop it there. If you can ask, and again, we've into the next speaker's time. Can you do yours real quickly?
Real quick.
Go.
Go ahead, Representative Harden.
With the current system we have set up, we have people who actually say break into a house. They truly believe there. Should these people actually run into the criminal system? Could we, or should they go straight over into some sort of a mental system and keep them out of the criminal justice? They had no clue what they were doing.
Yeah,
if you understand what I'm saying.
trespass after forbidden is very common, mental health type charge. And in Tulsa County, those folks may often be booked or at least taken to front door Tulsa, the Crisis Care Center, for an evaluation. If the person is sort of already known to jail staff or to perhaps the Crisis Care Center, between the initial A&B report and the time of filing, that charge is often dismissed, and they are often sent over to civil mental health court for diversion. Now, sometimes we have folks who have had that trespass 4, 5, 6 times because of delusional thinking patterns, and then protective orders become important, violations of protective orders come next, and then we go from there. Sometimes those folks become qualified for a criminal mental health court program that has a little more, perhaps, teeth in enforcement. Should someone with a first-time trespass be in the criminal justice system? Not long, in my personal view, without knowing the facts. Yeah.
Judge Pace. I'm sorry. Thank you very much. Wealth of knowledge. We appreciate that so much. It's an honor just to have you here and knowing what you're doing there for us, and we appreciate that very much. Thank you.